Sure. Initial J, middle name Morgan, last name Kousser, Kousser. I'm professor of history and social science, California Institute of Technology, or you could say CalTech, one word, CalTech. We're familiar with voting by districts. We never think of voting for all members of Congress in California in one consolidated ballot with 53 members on it. With the 2016 amendments of the CVRA, the attempt was to encourage a voluntary bureaucratic process rather than a more expensive and more involuntary judicial process. It has generally worked like that. There's a required process for public hearings. The idea of that process, I think, is that public hearings are a cleansing process, and that if you drew districts that were so obviously misshapen and self-serving, the public outrage would be something that you wouldn't want to put up with. If you will allow me to be a little rhetorical, the purpose of the law, more in general, from the very beginning, when Joaquin Avila wrote the law, he's a voting rights attorney, died last year, he's a good friend. The purpose of the law really is to integrate Latinos and Asian Americans, which are really growing minority groups in California, into the political process in the easiest ways possible, in the most frictionless ways possible. It's an attempt to make California's democracy happen smoothly. These are growing groups. They're growing almost everywhere. They had been shut out of power. They will want to get more power. They're having it on now in the state legislature and in some statewide offices, but in local offices it had been much more difficult to elect representatives of their choice. This is a way to make the transition much easier for everybody and to encourage the democratic process to go forward. The amendments to the CVRA, since it was passed, since it has had a lot of judicial, it has had some at least judicial oversight. Modesto case went to the U.S. Supreme Court, or it was appealed to the U.S. Supreme Court. The U.S. Supreme Court did not take cert on the case, but it went through a constitutional decision in the Court of Appeal. The way that it has developed since the beginning of the CVRA in 2001, 2002, just continued the whole process of democratization. And it has gone remarkably rapidly, remarkably smoothly compared to the Federal Voting Rights Act at the same period of its existence. And it's, I think, been good for California. It's allowed everybody to get representation and to go forward with lots of people having a stake in the government and a feeling that they are part of the government in a way that would not have been possible otherwise.
You know, we have 2 of our 5 council members who were elected in 2017 to 5-year terms. What happens to them?
Well, very often when district elections are put into effect under the CVRA, they are phased in. If their dwelling places are sufficiently far apart and fall into areas that might be considered reasonable districts, then there's an easy solution to that problem. I mean, that's up to you, but there's no necessity for keeping incumbents happy by putting them in districts where they would they would come up at the right time, or they would not have another person living in the district, some incumbent or serious potential incumbent. Those are not really particular concerns of this it's something that people will have to work out. Let me give you a couple of examples from cases that actually went to trial. In Southern California, in Palmdale, the two cases that have gone to trial, besides Santa Monica, are Palmdale and Highland. And in both of those cities, the several city council members lived very close to each other. So there were, I think, 3 city council people in Palmdale who lived within just a few blocks of each other. And in Highland, there were 3 who lived in one gated community. So there was an effort by the demographer who drew districts, who was associated in each case with the city, to draw very peculiarly shaped tentacles to try to put each person in a separate district. But particularly in Palmdale, the judge said, no. I can see what you're doing. The demographer who was working for the plaintiffs had drawn districts which were much more aesthetically pleasing, shall we say. So the judge accepted the districts drawn by the plaintiffs rather than these octopus districts that had tentacles to separate the people who lived, the incumbents who lived very close to each other.
The other question that I can see coming up is various, if not all, of the council members have pieces of downtown to represent. That unfortunately disaggregates most of the people that this CVRA is intended to help.
Right.
But if there's no judicial review and nobody raises a fuss, I guess that's what they can do.
They could, but maybe somebody will raise a fuss. People will say exactly what you said. This is the purpose of the CVRA, and you're undermining it by not drawing a district like that. And you could get sued under the Federal Voting Rights Act, which might allow a suit. It could even be that there could be evidence of that was done intentionally to crack the area of Hispanic citizens. I mean, it's a classic move. When they redistricted after Baker versus Carr and Reynolds versus Sims, when California had to redistrict its state legislature, one of the things that was notoriously done is that there was a concentration of Mexican Americans in East Los Angeles. And the Democrats who drew the assembly redistricting split East LA into 6 districts, so that every assembly district had a little bit of East LA, every assembly district around it. And the consequence of that was that you couldn't elect a single Latinx from that area, but all the districts were safely Democratic.